My client honored me by asking if I would be the trustee of their trust. Should I do it? This was literally a question I received from a colleague of mine not that long ago. This colleague's a realtor, a really good one, has a great reputation, and as a result has really great clients, long-lasting clients, people that trust him to make a good decision, help with the sale or purchase of property, to make a good referral. So this person has become such a trusted individual for one of his clients that they approached him recently and said, we're doing our estate planning and we wanted to know if you would be a successor trustee for us. We really want to be able to have our family rely on you just as we have relied on you. So the benefit, of course, is that they're going to know, these people, that there's a trusted a person who's going to be acting as trustee. But the question is whether or not this colleague of mine, this realtor, should accept that offer, should accept that responsibility. And he came to me and said, look, I think this is great. My clients really trust me, and it's wonderful that they want me to be able to be the trustee. And what's even greater is that, you know what, I can help facilitate the sale of their real estate holdings. And so this is really a great opportunity for me. What do you think? So I took a pause and kind of stepped back and I said, you know what? I think you should really reconsider. You should really be careful before you say yes. And here's why. The one main reason is, well, if you're the realtor, then you have a conflict of interest in being the trustee, because your function in being the realtor in a transaction when you're serving as trustee, there's a tension there. There's a conflict. Are you acting in the best interest of the beneficiaries of the trust, or are you self-interested in pursuing a sale or pursuing any transaction in which you're receiving an extra commission? Now, of course, this colleague, above board, not a person of ill repute, is going to do everything the right way, but it could look and could be argued that, hey, each one of these decisions in selling properties, was it really for the best interest of the beneficiaries? That's the inherent tension and the conflict in what we call self-dealing in trust and estate work. So self-dealing is something that's not allowed under the state of California unless it is expressly allowed in the particular trust. However, just not a great idea. So I recommended to my colleague, why put yourselves in the crosshairs? Even if a trust could be crafted to allow you to do this self-dealing, why would you do that? Because it's going to look potentially like other beneficiaries that if they disagree with your decision as trustee to sell a property and then you're selling it and getting commission out of a realtor, they have an easy argument that you're doing so for your benefit personally and not for their benefit as beneficiaries of the trust. So why do that? I say the same thing to financial advisors or CPAs, and those are individuals that also get this kind of question from clients from time to time. They're trusted professionals for their clients, built relationships over years. So naturally, when people are considering who to be their trustees, they think about these trusted professionals. But I say, look, these professionals, don't take the offer. Say politely to clients, say, thank you, I appreciate all the trust you've bestowed on me and asking me to do this function, but here's why I can't do it. There's a conflict of interest. Even if you're not going to act within your professional capacity in being the trustee. For example, you're not going to be the financial advisor for the trust. You're not going to be the realtor for the trust, even though that is your profession. I still say you might want to think twice about being a trustee for somebody else, whether it's a client or friend or family, just in general, because there's a lot of responsibility. You have a target on your back. I often describe this to clients as when they ask me, well, who should I pick to be a trustee? Which one of my family, which one of my friends, which one of my kids? Well, which one do you want to give the shirt with the target on it? Because that person's going to have a lot of responsibility. And if they mess things up or be perceived to have messed things up, then certain people are going to go after them. They have all the liability of the trust. So you might want to consider utilizing a professional trustee, individual or corporate trustee. So if you are a professional out there and you have great relationships with your clients and they've come to you and asked, hey, will you be my trustee, whether in my trust, whether on whatever successor trustee level, will you be my executor? I strongly ask you to reconsider that situation. Think through the optics, think through the actual legal conflicts of interest, think through the potential for conflict later, think through the liability and risks that you'll be taking on. And I think if you do that, you may reach the same results as I did for my colleague and friend, was politely decline and say, thank you for the compliment, but I'd love to serve you in other ways. My name's Kevin Snyder. I'm an estate planning and probate and estate litigation attorney at Snyder Law. I hope you enjoyed the segment, got a lot of value from it. And if you did, we have a lot of other videos in our library. The whole goal here is to provide you with knowledge, things that we see on a daily basis we want to bring forward to you so we can peel back the layers on what seems confusing, sift through all the other information that's out there in the world, and get to the heart of the true issues and really sound information that's out there, because knowledge is power. But the other part is what you do with it. So if we can help in any way possible to help you do something with the knowledge that you have, we'd be happy to. So in the meantime, continue to be amazing.